FBI nominee Wray before August recess. Senate Majority Leader Mitch McConnell plans to install Christopher Wray to lead the FBI before senators leave Washington for the August recess, a spokesman for the Kentucky Republicans said Monday. Wray, who has been nominated to replace the fired James Comey, breezed through his confirmation hearing before the Senate Judiciary Committee last week, and has since picked up support from several key Democratic senators. Republicans don't need Democrats to confirm Wray, but they do need their cooperation to hold a speedy vote, and Democrats have recently been dragging out consideration of even non-controversial nominees. We intend to confirm Christopher Wray before the August state work period, McConnell spokesman David Popp said. Even though Senate Democrats have brought unprecedented obstruction to the nominations process this year for no good reason, we hope they do not sink to a new low and force the first-ever cloture vote on an FBI director nominee. Senator Chuck Grassley, Iowa, who chairs the Judiciary Committee, has scheduled a panel vote on Wray's nomination for Thursday, although any one senator could ask for it to be delayed 1 week. McConnell also has 2 additional weeks of session to try and confirm Wray, with the start of the annual August recess being pushed back until mid-August. Wray does face some opposition from liberal Democrats. When Wray was announced as President Donald Trump's FBI pick in early June, Senator Jeff Merkley, D.R., tweeted several criticisms of the former Justice Department official, including that he is a GOP donor, represented New Jersey Governor Chris Christie during the so-called Bridgegate scandal, and that his law firm, King & Spalding, represents Trump Trust and Russian oil. A DOJ official has said Wray never worked on any issue involving Trump's business holdings, and a spokeswoman for King & Spalding has said the nominee has not represented Russian companies or individuals during his time at the Trump fights demand he testify in ejected protesters' suit. Lawyers for President Donald Trump are fighting an effort to force him to testify in a lawsuit brought by protesters at a campaign rally in Kentucky last year who say they were roughed up following Trump's call to get him out of here. In a filing Monday in federal court in Louisville, Trump's attorneys argue that a suit brought by the protesters can be resolved without exploring the motivations for, or intentions behind, Trump's exhortation at the March 2016 event. Compulsory deposition of the sitting President of the United States must be treated as a measure of last resort. It cannot be justified unless all other possible grounds of resolving the case have been exhausted, and the deposition is absolutely necessary, the new motion from the Trump legal team argues. Trump's attorneys, Supreme Court litigator Michael Carvin of Jones Day and Kentucky Attorney Kent Westbury of Landrum and South, say there's no plausible interpretation of Trump's words that can be seen as urging an illegal act, particularly since he also said from the podium that day, "Don't hurt him." When a speaker's words do not convey an intent to bring about lawless action, the inquiry into intent is over. There is nothing to ask President Trump because his words speak for themselves. His statement "get him out of here" conveys no intent to cause violence. It was merely a lawful request to remove disruptive protesters from the private political event, Trump's lawyers wrote. The request for a protective order to block Trump's decision is the latest tactic Trump's attorneys have used in an effort to stave off or shut down the suit 3 protesters filed about a month after the 2016 rally. They named Trump and his campaign as defendants, along with several other individuals, including an alleged white nationalist. U.S. District Court Judge David Hale has generally rejected those efforts, ruling in March of this year against the bulk of Trump's attempt to get the suit dismissed on First Amendment and other grounds. Trump's team also argued in a filing earlier this year that he is immune from civil lawsuits while serving as president, notwithstanding Supreme Court precedent to the contrary. Trump's attorneys also argue that he wasn't directing his comments to the crowd when he spoke of removing the protesters. One of the individuals sued in the case has filed a counterclaim against Trump, arguing that if any damages are owed then Trump should pay them. Trump's legal team has asked Hale to reconsider his ruling refusing to dismiss the case. If he won't do so, the president's lawyer wants to appeal to the Sixth Circuit Court of Appeals. However, the judge has not granted permission for such an appeal, which would typically have to wait until the case is resolved. The suit is one of several Trump's campaign is facing over alleged assaults on protesters and other activities during the 2016 race. A spending disclosure filed Saturday showed the campaign paid $538,265 to Jones Day in the second quarter of the year, up from $190,306 in the first quarter of 2017. Those figures are believed to contain the costs of fighting the protester litigation as well as legal work related to more mundane campaign-related matters. Trump administration certifies Iran still complying with nuclear deal. The Trump administration said Monday that it has certified to Congress that Iran is still complying with the terms of the 2015 nuclear deal, but it also promised to impose new sanctions on the country over its ballistic missile program and other alleged misbehavior. The Secretary of State and the President intend to emphasize that Iran remains one of the most dangerous threats to U.S. interests and to regional security, a senior administration official said on a conference call. The administration's announcement was part of a pattern emerging in its treatment of Iran, even when acknowledging that Iran is doing something that it wants. The administration nonetheless looks at other ways to increase pressure on the Islamic Republic. President Donald Trump has in the past bashed the nuclear deal, which was negotiated under his predecessor, Barack Obama, and he took office promising to reevaluate or possibly kill the agreement. But the latest recertification indicates that, despite the views of some hawkish Trump aides, those who favor upholding the deal have the upper hand for now. The 2015 agreement relaxed a range of U.S. and international nuclear-related sanctions on Iran on the condition that the government in Tehran dismantle its nuclear program. Iran is subject to international inspections under the deal. Congress has requested that the executive branch certify every 90 days whether Iran is complying. Unlike Obama's attempts to engage the longtime U.S. nemesis, Trump has made it clear he considers Iran an implacable threat, a view reinforced by Israel, Saudi Arabia and other Middle East allies of the United States. The administration is engaged in a broader review of the U.S. government's policies toward Iran, and it's not yet clear when that will be finished. On Monday, even as they said Iran was complying with the deal, senior administration officials took steps to bash the agreement, pointing out, for instance, that its provisions are not permanent. Although the agreement is strictly about Iran's nuclear program, the officials argued that Tehran was unquestionably in default of the spirit of the deal because of its interference in neighboring countries, its human rights abuses and other activities. Officials on Monday did not say when the new round of sanctions would be imposed. The U.S. argues that it retains the right to impose non-nuclear related sanctions on Iran despite the 2015 agreement. But such moves could lead Tehran to allege that Washington is the one violating the spirit of the deal, and prompt its ultimate unraveling. Asked if the administration wants to see regime change in Iran, one official said, "We're looking for a change in the regime's behavior." The Trump administration last certified that Iran was in compliance with the nuclear agreement in April. That announcement was coupled with a press conference in which Secretary of State Rex Tillerson denounced Iran's human rights violations, sponsorship of terrorism and ballistic missile tests. The United States still has a range of non-nuclear related sanctions on Iran, and Trump has beefed those up. In May, the administration announced it would keep waiving nuclear-related sanctions on Iran, but that it was imposing new sanctions on the Islamic Republic over its ballistic missile program. The nuclear agreement was negotiated with the participation of other leading countries, including Germany, Russia and China. And for now, those other countries have urged Trump not to weaken or abandon the deal. Trump's NAFTA goals draw from TPP, campaign pledges. The Trump administration on Monday released long-awaited goals for renegotiating the North American Free Trade Agreement, borrowing heavily from the discarded Trans-Pacific Partnership Agreement and putting a strong emphasis on reducing the bilateral trade deficits with Canada and Mexico. Too many Americans have been hurt by closed factories, exported jobs, and broken political promises, U.S. Trade Representative Robert Lighthizer said in a statement. Under President Donald Trump's leadership, USTR will negotiate a fair deal. The administration's decision to target trade gaps with Mexico and Canada as a negotiating goal is a significant departure from past practices. It also is one that may be hard to achieve, since many economists argue the deficit is driven by macroeconomic factors, rather than the provisions of trade agreements. However, it reflects Trump's apparent belief that the United States' $63.2 billion deficit with Mexico and $10.9 billion deficit with Canada are signs that the current agreement has failed. The Office of the U.S. Trade Representative said it wanted to keep many provisions of the 23-year-old agreement while bringing it into the 21st century. The proposal aims to add rules to govern digital trade, state-owned enterprises and currency practices. That will be a relief to farm and manufacturing groups worried about losing sales to Canada and Mexico if tariffs are reimposed after years of duty-free trade. We must preserve the advantages that our manufacturers, service providers, farmers, workers and consumers now enjoy with respect to NAFTA across our economy, House Ways and Means Committee Chairman Kevin Brady, R. Texas, said. Maintaining existing benefits, plus improving our access to Mexico and Canada, will allow us to continue to create American jobs, spur economic growth and open up new opportunities for all Americans through NAFTA. The objectives also reflect Trump's insistence on reshaping the pact to try to bring back jobs to the United States. In one example that could affect North American automotive trade, the goals call for tougher rules of origin to ensure that the benefits of NAFTA go to products genuinely made in the United States and North America. The goals heavily discuss maintaining the United States' ability to impose trade remedy measures, such as anti-dumping and countervailing duties, against imports that it believes are unfairly traded or that threaten domestic industries. Those provisions are likely to resonate in the industrial Midwest. In a related vein, the White House wants to eliminate a chapter in the current agreement that established a special tribunal for NAFTA countries to challenge each other's anti-dumping and countervailing duty decisions. They also have targeted another provision that excludes NAFTA partners from emergency safeguard tariffs that could be imposed to protect a domestic industry under stress from imports. But House Democrats, who may hold the key to the fate of the renegotiated pact, blasted the objectives as overly vague and said they made it seem as though the administration is only seeking to bevel the edges of a trade pact in need of an overhaul. The summary of objectives published today raises more questions than it answers, Representative Richard Neal of Massachusetts, the top Democrat on the Ways and Means Committee, said in a statement. In certain areas, there continues to be a complete lack of clarity or specificity, suggesting the administration may not even know what it wants in a new NAFTA. Neal and Representative Bill Pascrell, DN.J., ranking member of the Trade Subcommittee, both criticized what they saw as a step to incorporate aspects of the TPP into NAFTA 2.0, even though Trump vilified the Asia-Pacific Pact during last year's campaign and pulled out of it on his third day in office. The objectives reveal an approach to trade negotiations that looks like the same, conventional approach taken in previous trade agreements, suggesting that the new NAFTA might not be new at all, Neal said. It looks as if he wants to take the contents of the TPP, a deal he rejected in his first week in office, and call it NAFTA, Pascrell added. The document does not directly address the inclusion of or any alterations to the controversial investor-state dispute settlement mechanism, which labor and environmental groups want to be dropped in any revamped deal. They charge that the system undermines the right of governments to regulate in the public interest by giving companies a special forum to challenge government decisions that they believe have adversely affected their investment in violation of the pact's rules. The document's investments section simply mandates that a deal should secure for U.S. investors in the NAFTA countries important rights consistent with U.S. legal principles and practice. The objectives do outline expectations more broadly for dispute settlement, such as making procedures more transparent. However, it's unclear whether those demands apply only to disputes under the agreement between governments or whether private companies would also be subject to those rules. We must be sure to enforce new and current rules through effective dispute settlement provisions, including the proven tool of investor-state dispute settlement, Representative Dave Reichert, R. Washington, chairman of the House Ways and Means Trade Subcommittee, said in a statement. The need for modern trade rules is clear, particularly in light of our withdrawal from TPP earlier this year. Another top Republican said the objectives should have gone further in pushing for stronger protections for intellectual property rights, among other areas. If we are to truly modernize NAFTA and establish the most advantageous rules for selling American goods and services around the globe, future negotiating objectives must include stronger protections for intellectual property rights, upgraded rules and enforcement procedures for American exporters and investors, and improved regulatory practices that treat American goods and services fairly, Senate Finance Chairman Orrin Hatch, R. Utah, said in a statement. Senator Ron White of Oregon, top Democrat on the Finance Committee and a vocal advocate for implementation of stronger digital trade rules, criticized the provisions included in that area as lacking the level of ambition I would expect given the promises this president has made. Canada's and Mexico's top trade officials declined to comment on the negotiating objectives. Ottawa will be ready to work with our partners to modernize NAFTA, while defending Canada's national interest and standing up for our values, Canadian Foreign Affairs Minister Chrystia Freeland said. USTR is required under U.S. trade law to publish negotiating objectives 30 days before it begins talks on a free trade agreement. The first NAFTA round is expected in mid-August, although no date or location has been announced.